as Ross has said, Kilmore was a pretty amazing case in terms of the amount of expert evidence and the complexity. And the question's got to be asked, well, what on earth can we, how's that applicable to something in the Magistrates Court or the County Court or the Building and Property List at VCAT? And I think the answer is your issues in dispute and the amount of the claim will always inform your strategy. There's no doubt about that. And there are things you do in a $500 million case that you're not going to do in a smaller case, and that's fine. But a lot of the things are absolutely no different. And the same principles and some of the things that have come out of the rulings will be applicable to any case. The first point to note is that unless you're in the Magistrates Court, if you may, even think you may adduce expert evidence at trial, you need to seek directions. And again, that relieves the trial by ambush scenario. And effectively the court can make orders for pointing when service is going to be, what the issues are going to be, limiting the number of experts, or the catch-all any other direction. So start to think early on about, know the bench, think what the court might do and how you want to go about your case, but there's also the broad powers under section 49 and they apply before a hearing or during a hearing. Moving to the selection of the expert. If it's one thing that was the case in Matthews, and it's the case in any case, is the selection is absolutely critical. No matter how much money's at stake, you need to put the time in. Now, the first point of call is probably going to be Professor Google, and then you will refine that thinking and that research. I would suggest that the best thing to do is to speak to your colleagues. Speak to other barristers and solicitors and get some recommendations, and even once you've got some names, bounce those names around. Comedians usually open with a line like, oh, funny thing happened on the way here, or funny thing happened to me yesterday. As true as I sit in this chair, a colleague on my floor came into my chambers at 5 o'clock yesterday afternoon, just back from a one-day hearing in a building and property list matter at VCAT. Did the debrief. I said, how'd you go? I said, expert, hopeless. Just didn't, the report was good. He said he'd given evidence a lot of times before. I think he had, just didn't come up. It happens. It happens. And I think one of the takeaways is that if you're not arguing about millions of dollars, the margin for error is just not there. You've got to get the right expert, get the report right, make sure it's admissible, make sure it's based on things you can prove, because to have to go and get a second report or to ultimately have the expert not perform in the box is going to give you an unhappy client.